State We the People coordinator, and the judges will begin by introducing themselves to you. If you could then introduce yourself to the judges, and we'll have a conversation. I'm also your timer.
Good morning. I'm Dr. John Augenbaugh. I teach political science at Virginia Commonwealth University. To our left,
My name is Terry Fox. I'm a appellate judge in Colorado.
to my right,
And I am Mr. No Nameplate. I left it in Wyoming. Just gonna wing it here. I'm Mike Kelly, former family court judge in West Virginia, currently practicing attorney, and I spent 3 wonderful years living in Oregon.
and you are.
Good morning, judges. Thank you so much for being here. We are Unit 3 from Grant High School in Portland, Oregon. My name is Elijah Martin Collier.
My name is Kai Markle.
I'm Alice Parker.
I'm Dylan Jacobs.
My name is Madelinsky, and this is our teaching assistant principal, and we are very excited to be here.
Nice to meet all of you. Today, for Unit 3, we're going to discuss question number 3. Question number 3. At the Virginia Convention, Patrick Henry reminded delegates that the Articles of Confederation expressly declared that every right was retained by the states respectively, which was not given up to the government of the United States. What would have motivated Henry to highlight this clause from the Articles of Confederation? To what extent, if any, did issues of state sovereignty continue prior to and during the Civil War era? Which of these issues, if any, did the Reconstruction Amendments resolve? You may now begin.
Anti-Federalist Patrick Henry highlighted this clause from the Articles of Confederation because he wanted to maintain Virginia's sovereignty and prevent a despotic federal government. In 1787, states considered themselves akin to sovereign nations and often ignored the Confederation Congress. Anti-Federalists feared that the new federal government would eliminate state sovereignty through taxation. Luther Martin wrote, "The framers' object is the total destruction of state governments." Henry, therefore, advocated the absolute necessity of a Bill of Rights. He explained before the Virginia Convention how the English monarchy had repeatedly infringed upon the rights of its citizens until they established the English Bill of Rights in 1689. When the United States Bill of Rights was ratified, this clause Henry highlighted had become the 10th Amendment.
After ratification, many framers believed that states could nullify federal laws if they violated the Constitution. When President Adams signed the Alien and Sedition Acts in 1798, Madison and Jefferson wrote the Kentucky and Virginia resolutions, arguing that these acts were null and void because they violated the U.S. Constitution. Supporters of state sovereignty used similar arguments to void the Tariff 1828, resulting in the 1832 nullification crisis. Voting regulation also is another issue of state sovereignty. Article 1, Section 2 delegates voting regulation to the states, which causes discrepancies in voting regulations throughout states. For example, allowing states to restrict African American suffrage.
Slavery was also an issue of state sovereignty, as Southerners rejected federal interference with their rights to own slaves. The South supported strong federal power when Congress passed the Fugitive Slave Act of 1850, which allowed the federal government to deputize citizens to return escaped slaves to the South. However, South Carolina used state sovereignty to justify secession a decade later, writing in its Declaration of Secession that each state retains its sovereignty, freedom, and independence. The 1857 case, Dred Scott v. Sanford, limited the federal government by prohibiting Congress from outlawing slavery in its territories. During the Civil War, the Confederacy struggled to support its army because it lacked the strong central government needed to raise taxes and build infrastructure. Historian Frank Housen notes that the Confederacy died of states' rights.
Before the Reconstruction Amendments, nearly 1/5 of the U.S. population was enslaved. The 13th Amendment outlawed slavery, and Section 2 allowed Congress to enforce that article by appropriate legislation, expanding Congress's power to enforce equality. The 14th Amendment was passed to resolve the ambiguity of citizenship, lack of due process, and racial inequality under law. Although it was initially limited by the 1873 slaughterhouse cases, the 14th Amendment eventually expanded federal power to prevent state legislation that abridged these rights.
The 15th Amendment also decreased state sovereignty by prohibiting voting regulations based on race or previous conditions convict leasing, literacy tests, and black codes prevented the goals of the Reconstruction Amendments from being realized until decades after their ratification. Judicial interpretations of the equal protection and due process clauses eventually limited state sovereignty in pursuit of equality. However, states continue to disproportionately incarcerate African Americans, attack affirmative action, and limit suffrage, blatantly disregarding the Reconstruction Amendments. Thank you. We are now ready for your questions.
Thank you. Please put away your cards. Terry, would you like to begin our questions, please?
Sure, I think you started us on the track that I'd like to continue, about whether the Reconstruction Amendment, settled the question. How is it that we are seeing the issue of state sovereignty, play itself out in, present day?
Well, for one, gun control. Recently on March 28th, Kentucky passed House Bill 153, which prevented state actors from enforcing any federal gun legislation. And State Senator Philip Wheeler argued that this was consistent with liberal sanctuary city and state policies prohibiting state officials from enforcing federal immigration laws.
These ideals were upheld in the 2022 case, New York State Rifle and Pistol Association v. Bruin, which allowed the public use of firearms throughout the state of New York.
Abortion has also recently become an issue of federalism as the Dobbs v. Jackson decision overruled the Roe v. Wade, which had protected abortion federally, and now it is left up to the states. Immediately after following the decision, 13 states began enforcing their trigger bans, including Texas. However, in California, they expanded the right to vote, and with Proposition 1 that they put up to a referendum in the 2022 midterm election.
COVID also became an issue of federalism as many states, such as Florida and Iowa, pushed back against federal regulations such as mask mandates.
And voting regulations are also an issue of federalism. The 2013 case Shelby County v. Holder removed the federal government's pre-clearance right, which was in Section 4B of the Voting Rights Act of 1965, meaning that all voting restrictions are now left up to the states. And this has allowed for widespread voter restrictions in many states, such as Georgia Senate Bill 202, which famously makes it illegal to distribute food or water in a voting line.
Thank you. Mike?
Do you think early on in the Civil War that Lincoln felt constrained in his actions by a belief in state sovereignty? And if so, what caused that to change?
Yes, in Lincoln's first inaugural address in 1860, he said that he had no intention of removing slavery or interfering with slavery in any capacity in the South. And he believed that the Emancipation Proclamation, which he issued in 1863, was only justified based on his war powers.
Further, in his first inaugural address, he addresses the constitutional issues of secession as opposed to the issue of slavery itself. However, in his much shorter second inaugural address, he comes after the issue of slavery and argues that the Union must continue the fight against it during the Civil War.
However, in this book, The Second Founding by historian Eric Foner, he describes how Lincoln believed first that slavery should be solved through the states. Lincoln did not want to abolish slavery until the southern states had agreed, and he believed that this was more important than going to war, although eventually he did come around to the 13th Amendment and the Emancipation Proclamation.
It is interesting also to note that in 1861, Lincoln actually supported the proposed Corwin Amendment, which would have protected slavery and prohibited Congress from interfering with slavery in all of the states.
Thank you. Near the end of your prepared remarks, you made reference to the application of the Bill of Rights to the states via the 14th Amendment. What is that process called, and which, shall we say, iteration of that process would you guys advocate for?
This process has been called the court's selective incorporation, in which the Supreme Court applies the provisions of the Bill of Rights on a case-by-case basis rather than all at once, like John Bingham, one of the framers of the 14th Amendment, intended.
This was first established in the case Chicago B&Q Railroad Company v. Chicago when the court applied the Fifth Amendment to states.
However, the framers of the 14th Amendment, such as John Bingham and Thaddeus Stevens, originally intended to have total incorporation through the Privileges and Immunities Clause of the 14th Amendment. However, the total incorporation would have applied all of the Bill of Rights clauses to the states all at once the amendment was passed. However, obviously this did not happen. Now we have essentially total incorporation because there are only 3 clauses left that have not been applied to the states.
These clauses are the Third Amendment and the Seventh Amendment. Third Amendment, right against quartering soldiers in one's house. The Seventh Amendment, which is jury trial in civil cases. Additionally, the Fifth Amendment's clause for guaranteeing a grand jury indictment. And what's important to note about this is that while it may seem like a big gaping hole in incorporation, the Fifth Amendment's right to a grand jury indictment is in almost all states protected to a greater degree, allowing for, in some cases, a hearing before indictment.
Which means that ultimately supporters of total incorporation such as Thaddeus Stevens and John Bingham, as well as Justice Hugo Black, their vision has been realized, and we have almost in effect total incorporation at this point.
All right, Terry?
I mean, you told us that, obviously states can formulate their own laws independent from federal law, but, how do we reconcile, inconsistencies in those laws?
I think that inconsistencies is almost an advantage sometimes because states have we have a very diverse set of states, and states are able to meet the needs of their smaller communities at a greater extent. And so sometimes these inconsistencies can be advantages because different communities in different states want and need different laws.
And this was demonstrated in, for example, the mid-1800s when states like Indiana in 1824 and Connecticut in 1828 passed personal liberty laws allowing for jury trial for escaped slaves to receive jury trials upon appeal, which was denied to them by the 1793 Fugitive Slave Act. And so discrepancies can sometimes guarantee liberties that the federal government does not guarantee.
However, these laws can be struck down by the federal government. As the example my colleague pointed out, was struck down in the 1842 case Prigg v. Pennsylvania, which did not allow states to grant these trials to fugitive slaves.
Additionally, through the Dormant Commerce Clause, states cannot impose laws that present an undue burden on interstate commerce or restrict interstate commerce, like in the case Bibb v. Navajo Freight Lines.
And finally, Article 6 of the Constitution, of course, the Supremacy Clause, grants federal laws, federal laws supremacy over state laws.
And this was the original, this was one of the first iterations of state sovereignty being argued by the Anti-Federalists. In Brutus 17, he argues that the Supremacy Clause would overrule any state laws, making the federal government, making the United States one government as opposed to 13 different governments.
Okay.
About a month ago, Congresswoman Marjorie Taylor Greene said that she thinks the conservative states, now shut up.
Terry, please start us with feedback.
Wow. I don't have a whole lot of feedback because I was just so entertained and engaged and interested in what you all had to say. The amount of different authorities that you cited to us was just absolutely impressive, all the way back to Brutus 17. And how you brought it forward, I think was also, I mean, that's where I can tell that you know your stuff really, really well. And you can tell us how it's currently being, showing up in our lives. And yeah, you guys are ready to go to law school. Skip.
Mike?
I would honestly say that you did better than some of the second, third, 4-year lawyers that appeared in front of me. I would be honored to have any of you appear in my courtroom. Your presentation was great. Forthright, kept eye contact. You opened up early that slavery was an issue. I had a curveball question that was working just fine until you answered it before I got to ask it. And I just thought you were great. The reference to Eric Foner, we're sort of kidding about this. He's my favorite historian. And you know, he is the authority on that era. So I really enjoyed that. Some of the things we had never heard before, which is just the fact that 1/5 of the country was enslaved at that time and disenfranchised. And what caused Lincoln to change it? Did you hear of contraband? Black slaves who left to go to the north were considered contraband, and therefore he could use his war powers to free them because it undercut the South's ability to fight the war. So I thought you all just did fantastic.
Yeah, I really don't have much more to add. I'm gonna shock my colleagues when I say I don't even have any areas of improvement.
He's Oscar the Grouch. You did great.
And as a point of comparison, I would love to have each of the 5 of you in my upper level constitutional law classes right now. So, because that was impressive. And even more impressive to me was the way you responded to our questions. Nothing seemed to throw you. You had references that were on point in response to our questions. And that was impressive, guys. And so, thank you. That's all I gotta say. Thank